Welcome to Scale of Justice on Global Television. We are in Abuja, Nigeria's capital. I'm delighted to have you join us here. I'm Uyi Agumofwebe. This week, we turn our attention to a very, very crucial issue, which is the subject of reforms in both the legal system and the judicial sector of Nigeria. And then you get to hear lawyers often talk about how the reforms are critical if we need to get it right in that all-important sector of our national life. Time and again, in particular, we've heard instances of how that enforcing court judgments becomes a very important issue, in fact, becomes a challenge in most cases. Maybe an example that readily comes to mind is the verdict of the Supreme Court on local government autonomy. For many people, they say as beautiful, as historic, and as much of a landmark that verdict is, it is still going to pose a challenge in the area of enforcement. But while Nigerians keep an eye out looking at how that will pan out, I want to take a very important look at the factors responsible for all of these impediments that we see when it comes to enforcing court orders in Nigeria. My guest will help us shed light on this and provide us very valuable insights right after this short break. Please don't go away. Thank you for staying with us. My guest on the program today is a legal practitioner, one who is not only excited, but very passionate about this sort of conversation. Olaniyi Anjorin. It's a pleasure to have you on the program. First, I had to be very careful with your last name. I don't want you to score me on a scale of 10 because I'm not so sure what I will score. But then, would like to say a big thank you to you for making our time to come.
Thank you very much for having me.
You're a lawyer, apparently. You understand better what the procedure is. You also are very familiar, I'm sure, how that in most cases in this country, there's a court judgment, regardless of the class of courts, whether it's the High Court, the Appeal Court, or the Supreme Court, even the customary court, for example, or in some cases, some special offenses courts. You still realize that you hear stories about, we have not seen the judgment, we are studying the judgment. We have not been served. We couldn't serve the man. Sort of all kind of excuses and so on and so forth. You want to substitute service, blah, 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 blah. What are the elements responsible for this reality?
Thank you very much. It's my pleasure to be here. And when we are talking about orders, let's start from orders. Orders are meant directives. They are sanctioned pronouncement by courts, which are legally binding on the parties. And one fundamental element is that when an order is issued, it must be clear, it must be precise, and it must be served on the parties which that order is meant to be. So if a party is not aware, because the essence of issuing an order is for parties to be bound, court orders are not meant to be in vain, so they must be enforceable.
Right.
So before it can become enforceable, it must be precise. The party, because when you are talking of orders, sometimes it is prohibitive in nature. Sometimes it is to mandate the performance of an act. So the person that order is made against must be served, must be aware of that order. Like you said, sometimes if it is difficult to serve the person personally, that's when the issue of substitute service comes up. You can paste it at the last known address of the person. You can publicize it in the newspaper so that the person will be aware that there is a subsisting order against him. And it is tried position of law that an order, irrespective whether you see it as it's not accurate, it's not correct, you see a fault in it, as far as that order is made, is valid, is binding until it is set aside by that same court or higher court.
Must be by that same court.
It can be by that, because when an order is made that is null ab initio, or the court does not have jurisdiction to have made that order, you can apply to that court to set aside that same order. Or you can go on appeal. So if you apply to court to set it aside, for example, if a court lacks jurisdiction, maybe the party is a non-juristic person, maybe you were not aware of the service, or you have the opinion that the court lacks jurisdiction, you have the right to take it to that same court to set it aside. And if that court fails to set it aside, you can go to the appellate court to review that decision.
Let's talk about how integral, how important jurisdiction is, because most times, especially where the cases are political in nature, the party on whom the order is served always wants to play the jurisdiction card. Talk to us about how important that is.
Thank you very much. Jurisdiction is a very important. When the court lacks jurisdiction, no matter the order, no matter the pronouncement made by that court, it's null and void. So, for example, when a court gives an order, let's say a court, maybe let's use fundamental right case. Let's say a court has given an order against maybe security agencies, and there is one of the elements of jurisdiction is lacking in that case. It becomes impossible if, for playing the card now, the party can file an appeal,
Right.
raise the issue of jurisdiction. And when courts, the issue of jurisdiction is very sacrosanct. Immediately the issue of jurisdiction is raised. That's why even if a matter has been adjourned to, the matter is for hearing, when the issue of jurisdiction is raised, it must be heard and determined before any further step is taken. So courts always are mindful of determining the issue of jurisdiction before taking any further step in the case. So it's very sacrosanct. So if a court gives an order and the party affected feels, okay, I want to appeal this decision, you can file an appeal. If the matter is still pending, maybe the order is interlocutory, can file an appeal, file stay of proceedings. That, okay, we have raised the issue of jurisdiction in court of appeal. This matter must be stayed pending when the court of appeal will determine on that issue of jurisdiction.
Right.
So sometimes it's that's why the institutional bottleneck of the judicial system, it's sometimes some parties use it. That's why it's called improper use of judicial process to stifle the judicial process. But for example, now under the ACJ Act, the Administration of Criminal Justice Act, it has removed stay of proceedings in criminal matters
Altogether.
Yes. So initially, before now, maybe it's a criminal matter. After taking a plea, maybe the prosecution tenders a document and you object, and court refuses your objection. You quickly go to court of appeal, file an appeal, file stay of proceedings. After court of appeal has decided that no, that document ought to have been admitted, you go to Supreme Court, file notice of appeal, file stay, that you have appealed to Supreme Court. Court should not go on with the continuation of the hearing on the matter. But the ACJ Act has removed that. That even if you have, you are dissatisfied with any decision of the trial court, you can go on your appeal, but the matter must continue.
Right.
So that is a new innovation in the ACJ Act. That's why you see criminal matters now. Whether you go to court of appeal, you go to Supreme Court, the trial continues.
Continues, yeah.
So that's.
I'm happy you mentioned the ACJ Act. Now, I spoke with a former Attorney General in the States. At the time, he was the serving Attorney General in that state about the ACJ Act. He said sterling things, impressive things about the ACJ Act. But a few years down the line, I see lawyers like yourself who still pick holes in the ACJ. Of course, we know there's no piece of legislation or rules of court anywhere or practice direction that is perfect anywhere in the world. But do we still need more reforms, critical reforms in the sector?
I think my own position regarding that conversation is the laws that we have. Have we really worked on them? Are we utilizing these laws
as they are now?
As they are. Okay, when you are talking about enforcement, there are various modes of enforcing judgments. When an order has been issued and a party flouts the other, their procedure to punish, to sanction such disobedient party. Sometimes we don't take, of course, we know there are some challenges,
Right.
but sometimes we don't take step to. Recently, I think last year, there were times that the Inspector General of Police, the former EFCC chairman, that committal proceedings were instituted
Against them,
Against
right.
them. Before now, hardly they would just court will give order, they will not obey. But recently, you see that judges are more proactive, irrespective of the president. Even the Supreme Court on the issue of local government autonomy that you talked about, and it's a welcome development. That, of course, laws are not perfect, but the ones that ACGI was 2015. So these acts, these laws that we have on ground, have we utilized them? Are we working to abide by them? Let's start with that before talking
Anything
about
else?
reforms. Yeah.
I think that sounds brilliant. So on that note, we're taking the quick break now, everyone. When we return, a lot more to talk about on the program. Do stay with us. Thank you for staying with us. This is apparently the second part, and of course the last on the program. So let's talk about some of those orders, court orders you mentioned a while ago, whether against the IG of police or maybe even the DG of the DSS, as the case may be. But we also saw one that was against the Chief of Army Staff, for example. We don't see those orders carried out. Is that a systemic problem beyond the judiciary?
Okay, like I said, it's all hands must be on deck for proper enforcement of orders and judgments. So when an order is issued, like I said earlier, it might be to prohibit, to refrain from doing an act, or to mandate a party to take a step. So if, and there are some orders that are referred to as being declaratory. We have executory orders. So declaratory orders are mostly not enforceable.
Okay.
They are just to state the rights of the party. For example, if security agents have breached someone's rights, the person can approach court and say, okay, I'm praying for a declaration that maybe the arrest, detention of the applicant by the security agent is unlawful, is unconstitutional. If court makes that declaration, court is only ascertaining that person's right. You cannot enforce it unless after the declaration, the other party now flouts that declaration. You can now enforce it. So declaratory orders, they just state your rights, your obligations. But when you are talking about executory orders will state the rights, the obligation of party, and will still go ahead to give direction, to make pronouncement of what to be done. For example, if a court finds that, okay, your right has been infringed, court can make pronouncement, issue an order that, okay, you go and do newspaper publication for public apology against the applicant. Court can say, okay, pay 5 million as damages. So after an order has been made, immediately when it is executory, enforcement, you can enforce immediately. So if the party fails to enforce, for example, if it is monetary, you go the issue of garnishing.
Okay.
Garnishing is if a court gives order that, okay, A should pay B, and B is the judgment debtor, has money in a bank. You attach the money, the monetary judgment, in the account of B in that bank. And the next step is that, okay, let the bank or the judgment debtor come and tell courts why the attachment should not be made absolute. So that is a mode of enforcing monetary judgment. So in that instance, concerning, since we are talking holistically now, another challenge about that is that since this issue of single treasury account
No, the TSA.
of the TSA. So if you have a judgment against, that's why you say these orders, they are not, you can't see them be enforced. When you have a judgment, for example, against government agencies that have accounts in TSA, by the provision of Section 84 of the Sheriff and Civil Process Act, when you want to attach any money in the custody of a public officer, you have to seek and obtain the consent of the Attorney General. So if you don't seek and obtain the consent of Attorney General, there's no way you can enforce any monetary judgment which is in the custody of CBN, for example.
Okay, let's say at the federal level.
Yes. Same applies to state.
To the
levels.
states, okay.
So for that, and there's no way it's hard, because most time when people go to court and they bypass that requirement, they are going to raise preliminary objection, the matter will be struck out. And there is no way, if you apply to Attorney General for consent, you have to hear from the government agency that somebody has applied though, what will the security or the parastatal will do? Quickly file notice of appeal or file extension and file stay of the execution and inform the Attorney General that we have appeal, we have filed that stay of execution. The Attorney General will not be able to give the consent.
It's helpless.
It's helpless. So you can't enforce that monetary judgment. And also, when a judgment is given or an order is given, and a party has filed an appeal, and if it's executory judgment, the party has filed stay of execution. Even if the stay of execution has not been had and determined, all parties must maintain status quo.
All right.
You cannot do anything that will make the decision of the hearing and determination of the application nugatory. So everybody must wait till that application is determined. So for example, if a Federal High Court or High Court has given a judgment or an order, and I file appeal to Court of Appeal, we have to file the stay of execution first at that same court. First is after its refusal, you can go to Court of Appeal. But if the record has been compiled and transmitted, you go to the appellate court. So if you file a stay of execution, maybe the order is that go and pay 5 million or go and release the person, and you file an appeal, you file a stay of execution, that order cannot be enforced. So
Let's talk about instances before the TSA was introduced under former President Goodluck Jonathan. How did it happen that we had so many cases, especially like you said, with MDAs, I mean, agencies of government and so on and so forth, institutions, all right, not obeying court order, whether it was monetary in nature or otherwise? People say it was rascally, especially in a democracy. What are the implications of that kind of practice?
it's not a good practice, because if court orders are not cannot be enforced, then it makes a mirage of the whole judicial process.
Right.
I think most times what they do, or what they were doing before the issue of TSA, is that when an order is given, like I said, it's an institutional bottleneck and improper use of judicial process. If a judgment is given or an order has been issued, and you file a notice of appeal and you file a stay of execution, you can't enforce that order.
Right.
You can't enforce that. And the way because of number of cases as Court of Appeal and Supreme Court, sometimes you can file a motion a year, 2 years, you will not hear that motion. So that's the problem. When because of the improper use of, and in this country, in this part of the country, it's hardly for like what you said, it's easier for you to enforce judgment, court order against private individuals than government, because they always, interestingly and unfortunately, they spend more money engaging even lawyers to defend those judgments, those orders, than even the judgment sum. Because at the end of the day, maybe judgment or monetary judgment is 2 million, 5 M. They can engage lawyer that will say, give me 10 million, 15 million, and you pay the lawyer instead of paying the monetary.
Is that not penny wise, pound foolish? Or is there a different point that entity wants to prove in this case?
From my own little experience, I think they just don't want that indictment that a judgment was given and we did not take any step. We just accepted it. So that's
That's a bit of maybe institutional arrogance.
my call.
I would like to say a big thank you to you, Olani Anjorin, for coming on the program today to share these very valuable insights with us. Thank you everyone for watching, and that's a full cycle on the program today. I am Uyi Agumofwebe, and this is Global Television.